Hello, welcome to the 42 Bedford Row Housing webinar series. My name is Niamh O'Brien. I'm part of the 42 Bedford Row Housing team, and I represent both landlords and tenants in the social housing sector.
My name is Louise Whittington. I'm co-hosting this seminar, and I also practice in the housing group and represent landlords and tenants.
Today we'll be talking to you a bit about antisocial behaviour orders, particularly focusing on the procedure and the new sentencing guidelines. I'm going to outline, first of all, for you the various different sources of the law in relation to the procedure that one has to follow in relation to antisocial behaviour and applications for committal for contempt of court for breach of any order. I'm doing this because there are four main sources of law regulating the procedure for those injunctions and for the applications to commit. However, they do overlap, and more importantly, they don't always refer to each other. So unless you know where they are and what they say and how to find them, you can fall applicants can find themselves falling into traps. I'm also going to talk to you about the new Part 81 of the Civil Procedure Rules. I say new, it's been in place for nearly 2.5 years. The new Part 81 was intended to consolidate and streamline the procedure for applications for committal for contempt of court. It's not only, I should say, concerned with antisocial behaviour. So it's not the whole story is not contained in Part 81. And also there are some gaps within Part 81, which have been considered recently by the Court of Appeal. And I am going to talk to you about those towards the end of my part of the presentation. And Louise, after that, is going to go over the new sentencing guidelines handed down by the Court of Appeal in the case of Lovett and Wigan. So first of all, let's look at the sources of the law relating to the procedure. There's four main sources that I'd like to draw your attention to. The first is section 1 to 13 of the Antisocial Behaviour Crime and Policing Act 2014. I'll be referring to that as either the 2014 Act or the ASB CPA 2014, which is probably just as much a mouthful as saying it in full. In addition, you should also be aware of Schedule 1 to the 2014 Act, which deals with the question of remands. I'm also going to talk to you about Civil Procedure Rules Part 65, paragraphs 42 to 49, and the practice direction which is attached to it. I'm just going to say at that stage, if you are looking for those rules on the Justice website, please be aware that some of the headings on the contents page are missing. So if you're looking at it on the Justice website, it's not automatically clear that this is dealing with the 2014 Act. There are references in the contents page which appear to refer only to the 2009 Act, but in fact parts 42 to 49 of Part 65 relate to both acts and will be the one that you'll be looking at for the purposes of applications by social sector landlords. And finally, that we'll be looking at the Part 81 of the CPR dealing with contempt of court. And this will be the part that we'll be looking at in the situation where the landlord is contemplating breach proceedings for breach of a civil injunction. Under the 2014 Act, this is a bit of a rattle bag, and I'm just bringing these to your attention because these are mistakes that I see being made. And if I'm telling you something that you already know, then congratulations, you haven't made these mistakes. First of all, the first point is a requirement. Well, so if you've got if you're looking for something which requires the defendant to do something, for example, in a hoarding case, you might be asking the court to require them in the first instance to clear out their property. If you are seeking that kind of positive requirement, you must specify in the body of the order the person or body who is to supervise compliance with that part of the order, and the court must have evidence both as to the suitability and enforceability of that requirement from that person. I frequently see draft orders where there is a requirement which just simply requires the defendant to do something, the court technically, well, not technically, cannot cannot make such an order without knowing in advance who is going to supervise it and why that person thinks, or that body thinks that that requirement is suitable and enforceable. The other point I want to draw to your attention is exclusion orders under Section 13 of the 2014 Act. They can only be granted in relation to somebody's home. First of all, if the defendant is over the age of 18 and there is both a history of the use and or threat of violence and a significant risk of harm to others. So you've got to have evidence of both of those limbs if you're seeking an exclusion order. Frequently, I have seen cases where there have been threats of violence, but the person who was the target of that is no longer in the locality. And in that situation, the grounds for making an exclusion order in respect to the defendant's property are not made out. Another point from the 2014 Act is that the police have 24 hours from the point of arrest to bring the defendant to court. And that's contained in Section 9 of the 2014 Act. If the defendant is not brought to court in time, the court must release the defendant. If the defendant is released, it's not the end of the story. The applicant, the person who originally got the order, can apply to the court in the normal way to commit that person for contempt for breach of the order if they wish to do so. The other point to remember is that it's not the end of the world if the applicant can't get to court in time before the person is produced. This does happen. If it does, the court will usually simply remand the defendant on bail and bring it back before the court in short order, but at a time that a representative of the landlord or the applicant can be there. Remands are dealt with, as I said, in Schedule 1 of the 2014 Act. Can I just make it clear? Remand in this context means in custody or in bail. There is often a practice of people using the word remand as shorthand for remanding somebody in prison, but remand in this context means both. Schedule 1 provides that a person can only be remanded in prison or on bail for 8 clear days. That means that Saturdays, Sundays and bank holidays are discounted. It is possible for the court to remand on bail for a longer period, but only if both the claimant and the defendant consent to that longer period. Bail can be subject to conditions, most usually not to interfere with witnesses. Obviously, if those conditions are breached, there is a risk that bail will be taken away on the next occasion. Although I have to say, in my experience, I don't think I've ever seen anybody be remanded in custody pending a hearing of a breach, of an allegation of breach. The reality is, if they've done something bad enough to warrant custody at that point, you would expect the police to have been involved at this stage.
It's likely to be an independent criminal charge.
I would have thought so. Yeah, it's if the police have left it to the landlord to deal with, the reality is it's not likely to be a case where you would expect the defendant to be refused bail. At this point, at the remand point, the court does have the power to remand to hospital for report if a mental disorder is suspected. And I've drawn that to your attention because of the recent case of NTA and the Commissioner of the Metropolitan Police and the Lord Chancellor. That case involved a defendant who had a severe developmental delay since birth. His mother's landlord sought an antisocial behaviour order against him. There was a complex procedural history of applications for orders and for committal and committal proceedings, both in Clerkenwell and Shoreditch County Court and in central London. It transpired after several hearings, after which the defendant had in fact been remanded in custody on at least 3 separate occasions, that he lacked both litigation capacity and a specific capacity, or we used to call working capacity, i.e. he lacked the capacity to understand and to comply with the order. That resulted in a claim being brought by the defendant against both the Metropolitan Police and also the Lord Chancellor. And the claim against the Lord Chancellor related to the several orders that were made both in Clerkenwell and Shoreditch and in central London, which had essentially resulted in the defendant being remanded in custody. And the claim was for damages for breach of the Human Rights Act. And you may have seen that certainly since those proceedings started, and particularly since the decision of the High Court in January of this year, which dismissed the Lord Chancellor's application for a summary judgment on the claim, that courts are very, very, very careful in these cases where there is a suspicion of a lack of capacity or a lack of working capacity. So in those circumstances, landlords should consider reminding the court of its power to remand to hospital for a report if mental disorder is suspected. Although that said, again, I have to say, in my experience, courts are reluctant to do that and prefer that either the defendant sort that out himself with the help of some of his legal representatives, or both the defendant and the applicant both together get some evidence before the court. But that, if that's not possible, that rule is there. Also, in relation to remands, there is an absolute 28-day limit. So if the court doesn't deal with the person following arrest within 28 days of the arrest, they can't deal with them at all. Again, it's not the end of the world if the 28 days expire between the date of the arrest and the date by which the court has the time to deal with it, because the applicant can still apply in the normal way for an order to commit. But just do be aware of that 28-day rule. Absent an application to commit by the claimant, the court must deal with the issue within those 28 days. Moving on to CPR 65. Again, these are just some points that I have seen coming up in practice that some practitioners may not be fully aware of. First of all, everything has to be served personally, everything, including the application for the injunction itself. And that must be served no less than 2 clear days before the hearing. And the reference for that is on the screen there. It's CPR 6543.5. And the definition of clear days can be found in CPR 2. And clear days means that if days within a rule are 5 days or less, it means business days only. So Saturdays, Sundays, Christmas Day, I think Good Friday and bank holidays are excluded. And obviously that you don't count the day on which the thing is done and the day of the hearing. So clear days might actually be an awful lot longer than you would think. So do keep an eye on whether or not the defendant has had a good service of the application. There is no express power within 65.43 to dispense with personal service of the application for the injunction. I draw this to your attention because, as I said, everything has to be personally served. The default is that the applications, the orders have got to be personally served. But both in relation to service of the injunction order and in relation to service of an application for committal for its breach, however, there is no express power to dispense personal service of the application for an injunction within 65.43. So what do you do if the defendant can't be served? If, for example, the defendant doesn't have a known usual address or is evading service? Well, the applicant then has got a choice of either proceeding as if it were a without notice application or making an application for substituted service. But both have their problems. I would say as counsel of perfection apply for both. if necessary, for the for it to be made retrospectively. The substituted service is dealt with in Part 6 of the CPR. I haven't put it up there, but long story short, if you are making an application for substituted service, you do have to have good reason for making that application, and not realising that the application had to be served personally would not amount to a good reason, in my view, unless there are very extenuating circumstances. As I said earlier on, the other alternative would be to invite the court to treat the application as a without notice application, albeit on notices in the fact to the defendant. But please do note, when representing both defendants and claimants, that if an application is made without notice, truly without notice, the duty of full and frank disclosure arises. So the applicant must set out any reason it is aware of that might count against making an order. For example, whether or not it is aware of any mental health issues, or whether or not, for example, the victim, if it's targeted antisocial behaviour, is no longer in the area for a particular period of time. The reality is that most landlords in the social housing sector should be doing this in any event. So that brings us to the new-ish CPR Part 81. I said it's been in force since the 1st of October 2020. It introduced a new form N600. So this is the form that has to be used, and not the N244, although technically this is a Part 23 application. The application must be personally served on the defendant, although in Part 81 there is the power to, there's an express power to dispense with personal service on the defendant, but again, you're going to have to show grounds as to why that can't be done. And as it was under the old procedure, the evidence in support of the application for contempt must be by affidavit or by affirmation. There was a couple of gaps in Part 81, which is unfortunate really, because it was meant to be, there was a lot of criticism about the way that the old Part 81 was structured. It wasn't particularly clear, and there were gaps in it. So the whole point of the new Part 81 was to have a streamlined procedure where all your rules were in one place and everyone would know what they had to do. And the reason that was necessary was because so many applications are being adjourned because applicants hadn't complied with the rule about which they weren't aware. However, there was one big gap within Part 81, which is it didn't actually expressly require the order which the defendant is alleged to have breached to have been personally served on him. Now, certainly there was a requirement in the old Part 81 for personal service of the injunction, but that was not within the new Part 81. So in the first case there on the first bullet point, MBR Acres and Mar, the High Court confirmed that notwithstanding the fact that it's not actually in the part, under the new Part 81, you are required to personally serve the underlying order which the defendant is alleged to have breached. However, that was swiftly followed by a Court of Appeal case of Business Mortgage Finance for PLC at Hussein, which confirmed that although there is a requirement for personal service, the court does have the power to retrospectively dispense with personal service. The two main differences between the facts in those cases that the defendant in the MBR case could have been personally served, but in that case, the claimant served the injunction on his representatives. In the second case, the defendant was in prison when the order was made during the COVID lockdown, so no visitors were allowed, so he could not be personally served, and on his release, he disappeared. But the Court of Appeal confirmed that it would be appropriate to dispense the service in that case to make that order retrospective. And there's two questions. Well, there's three questions. Is there a good reason for dispensing with personal service? Does the defendant have actual knowledge of the terms of the order he's alleged to have breached? And has the defendant been prejudiced in any way by the lack of personal service? So that's all I'm going to say about the procedure and some of the traps that can be there for the unwary. And I'll hand you over to Louise.
Thank you, Niamh. The second part of the seminar will be looking at the case of Lovett and Wigan Borough Council, Smith and Newark Homes Limited, and Hopkins and Optivo. This was a Court of Appeal case which was heard in 2022, and it's very welcome and helpful guidance on sentencing for breaches of antisocial behaviour injunctions. And what I mean by that, and following on from Niamh's part of the talk, is that where there is a antisocial behaviour injunction that's been made under Section 1, and then there has been an alleged breach, technically you are pursuing a committal application, so you're committing somebody for contempt of court. But previously there was very little guidance for the county court in how to deal with those cases and what the appropriate sentence was. On the screen you will see that there was, or I've noted that there was previous reliance by judges on the 2018 sentencing guidelines, which was for criminal behaviour orders, and that was guidance issued by the Sentencing Council. Criminal practitioners will be much more familiar with the Sentencing Council and the guidelines for lots of, or almost all, criminal offences. And what was interesting about this is that it wasn't specific for antisocial behaviour injunctions, but for what was considered to be a similar offence or similar issue, namely criminal behaviour orders or breaches of criminal behaviour orders. The key difference was that the maximum sentence under the 2018 guidelines was for 5 years, which lots of you will know is well in excess of the powers of the county court, where they're, in terms of their sentencing powers, for breach of an antisocial behaviour order, namely contempt of court, which is 2 years. The context or the background to this Court of Appeal case comes from the Civil Justice Council report from July 2022, which was the working group's investigation into the antisocial behaviour legislation, how it's played out since 2014, some of the issues that have been encountered, but also the issues with sentencing. I would recommend having a look at the executive summary of that report, which is available online, because it does make quite an interesting read, particularly some of the issues or lack of utilisation of the 2014 legislation generally. Specifically in relation to sentencing, and these are points which are addressed in the judgment, are there were concerns raised about inconsistency of penalties that were being imposed by the county court. Again, they pick up on the fact that the guidance, which if you look on the Sentencing Council website, it actually refers to, or the 2018 guidelines is applicable, in essence, to antisocial behaviour injunctions. The Civil Justice Council also considered the fact that the civil courts have very different powers, or quite different powers to the magistrates' court, and actually less resources and links with other community services. The magistrates' court has links with the probation service, powers to make community orders, something that's very different in the civil courts, who are a little bit more isolated, and the powers open to the judge are more isolated. There was quite a lot of criticism of the judgments or sentences that were considered as part of the working group's review. I think that they looked at about 50 different examples, and they considered that there was a huge disparity in the severity of the sentence imposed, and actually given the factual matters, that some people were being sentenced to quite a long custodial sentence, where in other cases, the breach of the injunction or the harm caused was much more serious, and they were being given either a fine or no order. The Civil Justice Council prepared or created Annex 1, which was in essence a framework very similar to that used by the Sentencing Council to help judges and help the court in dealing with sentencing for antisocial behaviour injunctions. And this was endorsed to some extent by the Court of Appeal, and I'll come back to that in a moment. So moving back to the case itself, you will see that this is three joined civil appeals with different facts. The facts actually of the cases are interesting, but of limited relevance. Actually, what was particularly interesting about the judgment was the general guidance given on sentencing, including consideration of the CJC report. There was a single agreed judgment by Lord Justice Burrs, and actually they did look at the framework for the Section 1 of the Antisocial Behaviour, Crime and Police Act and the powers that the court had. So dealing first with the general principles and procedural rules that were looked at. And I don't want to get too much into this because Niamh's very helpfully gone through, particularly CPR 81 and how that would apply. One point to note and something to focus on is the fact that the Antisocial Behaviour Act from 2014, it didn't create a special jurisdiction or set of rules that would only apply to those type of injunctions. And actually, in fact, the CPR 81 and the principles for making an application for contempt of court applied. And so it's the fact that there isn't a different statutory framework. I think it's quite interesting because the Antisocial Behaviour Crime Policing Act, it was an attempt to introduce a different method of civil enforcement for low-level ASB cases. Paragraph 27 of the judgment emphasised the importance or need for legal representation. And I think as a practitioner, it's helpful to always remember that, particularly where, as Niamh referred to earlier, individuals or defendants are brought before the court in short order within 24 hours of the breach. And at those hearings, even where a defendant admits the breach, the court should be quite slow to allow them to essentially enter a plea into sentence where they've not had the benefit of legal representation. And they are entitled to non-merits tested, or apologies, non-means tested legal aid. The other procedural point that was quite relevant in this judgment, and we'll come back to, is from CPR 81.8, subsection 8, which was the need to publish the judgment online and get a transcript, which becomes relevant in one of the conjoined appeals. So dealing first with the purpose, and the judgment really was trying to emphasise the difference between sentencing in ordinary criminal cases and sentencing for contempt of court. And if you're thinking about what is the trouble that you're trying to deal with in CPR 81 and contempt proceedings, and really what you're looking at is it's a breach of the court order and how serious that is and the consequences of that breach. And again, one point that was considered by the Court of Appeal in the judgment was the fact that the circumstances around contempt are somewhat more various because it depends on the circumstances in which the original injunction order was made, the circumstances in which they're arrested, and the fact that it could be quite a low-level piece of conduct as such that does amount to a breach, but does that then justify a custodial sentence or no order? It's just slightly more varied and less clear-cut than in a normal criminal case. It is the point that they were trying to make. And at paragraph 39 of the judgment, it was 3 objectives were identified, but actually the first was deemed to be the most important and should be in the forefront of the court's mind when making or when sentencing for breach of the injunction, which is predominantly ensuring future compliance with the order, so preventing future breaches and stopping there to be future issues surrounding antisocial behaviour that are already protected by that injunction already. And then secondary factors are punishment and rehabilitation. This is quite different to sentencing purposes. I think it's contained in section 57, but in normal criminal cases. And actually, paragraph 39 emphasising the fact that this is a hierarchy is quite important and quite a distinction from sentencing in other criminal cases. What is noted is that the civil justice reports focus on punishment being the first objective isn't correct. And that's where there is a divergence between some of the issues and focus of that report and the Court of Appeal's guidance, which was issued. The Court of Appeal went on to consider what powers there were in the County Court and High Court. And at paragraph 40, it sets out very clearly the 5 options open, which most people will be familiar with. Obviously, an order for committal to prison, so a custodial sentence, a suspended order with conditions attached or without, adjourning, a fine, or no order. As I've already indicated, the maximum term or maximum sentence that could be awarded in the county court for contempt of court is 2 years. What's interesting is that the court has no power, or the civil court has no power to make a community order. What is essentially difficult with that is the fact that if you think about antisocial behaviour and what the injunctions are seeking to protect other residents or people in the locality from, unfortunately, it's often related to noise and violence between neighbours or issues with drugs and alcohol. And yet the county court doesn't have the power to make an order for supervision, an order for a curfew, or for a drug rehabilitation programme. It's got quite limited powers for these breaches of the injunction. And what the Court of Appeal did was highlight the power, so this is at paragraph 41 of the judgment, of the court to, if necessary, to amend the original injunction if it's still in force, the opportunity to impose a variety of conditions. So that would be a positive condition to complete a particular course or for supervision, pursuant to section 1(4) subsection B of the 2014 Act. But please do remember, as Niamh very helpfully highlighted earlier in the talk, that you would always need to have the person who is going to supervise or ensure compliance with any positive requirement, which is quite a high threshold and means it needs to be considered in advance. But that is something that can be considered as part of the sentencing powers. I've set out paragraph 43 of the judgment in full on the screen, and I would urge you all just to pause the clip and have a read of that, because I think, certainly in my view, it's the most important part of the judgment. But I will just read the sections in bold, because again, they really go to the purpose of the legislation, or purpose of the sentencing guidelines, the fact that custody should be reserved for the most serious breaches and for less serious cases where other methods of securing compliance with the order have failed. So again, it's looking at the purpose of sentencing in this context. And a custodial sentence should never be imposed if an alternative course is sufficient and appropriate. And I think that links in very well with the next section of the judgment, particularly at paragraph 45, which is where it's possible, this I think was option 3 in the list that we've already considered, but it's the power to adjourn to consider sentencing at a later date. The best way to think of this is that the court does have the power, and obviously practitioners, if you're representing an applicant or a defendant in these hearings, could ask the judge to consider at a later date, because if the court sets out or gives a likely indication of the sentence and sets out any consequences of failing to comply with the original injunction order or any further antisocial behaviour that might not necessarily be protected, but further issues related to the property, the court then, at an adjourned hearing, could then impose a custodial sentence. Best practice is very clearly to have a recital to the order setting out, for example, at the sentencing hearing, the fact that the sentencing has been adjourned to a later date, the indication that's been given to the defendant that this could be the likely sentence, and what would happen, that would be imposed if they don't comply with the order at a later date. And that goes back to paragraph 43 of the judgment, that the custodial sentence is in essence a last resort, where somebody has continued to or has failed to comply with the terms of the injunction. Moving on to culpability and harm, which was again considered by the Court of Appeal. And in particular, this was looking at the Civil Justice Council's report at Annex 1 from their July 2020 report. What's clear is from the Court of Appeal decision is that this is not, it doesn't automatically apply, but it's helpful guidance, and certainly was considered to be more helpful than the 2018 Sentencing Council guidance on criminal behaviour orders. Criminal practitioners will be very used to looking at these types of table, which is in essence a grid system with different levels of culpability and harm. The CJC report or guidance that's offered has got 3 levels of culpability and harm. And I will actually set this out on the next screen for you to all to have a look at. And again, it's not meant to bind or fetter the discretion of the judge, but it does provide quite a useful starting point for the sentence and a bracket, depending on various factors to be considered. Some examples of factors which certainly were not meant to be exhaustive were set out at paragraph 49, noting particularly, for example, the vulnerability of a victim or the fact that there's a persistent breach. That was likely to be an aggravating factor, fitting into both culpability and harm, depending on what the issue was. Some mitigating factors or showing less culpability or less harm might be genuine remorse, ill health, or an early admission of the act, which is in contempt. And here is the relevant part of the table, which you'll be able to look at with some starting points and some brackets in essence, showing different factors which you could look at. And I would encourage you to, if you're representing or dealing with a case of sentencing for breach, that this is a very helpful starting point for the judge, because it gives a framework. And the language that was used was to help judges deal with it in a systematic manner, rather than a bit of a shot in the dark from no order to a 2-year custodial sentence. Finally, I just wanted to consider 2 of the appeals that were dealt with by the Court of Appeal in terms of the specific facts. And actually, this is dealt with in the latter part of the judgment, very much as applicability of the general principles which were just set out to actually the specific facts of the appeal. The appeal of Lovett and Wigan BC itself does not have much relevance in terms of actual sentencing, because it was about various, it was quite a convoluted case, lots of various appeals, including the challenge of the original injunction order, but it didn't deal with the sentencing principles themselves. Optivo and Hopkins did. It was a case in Croydon where Miss Hopkins was given a 12-week suspended sentence. And there were 2 parts of the appeal and 2 quite important decisions given by the Court of Appeal in upholding both stages. The first was about the applicability of the 2018 guidelines. And although it didn't say it was wrong for those to apply, it was very much felt that the categorisation of the breach by Miss Hopkins as a B2 offence was much too harsh, and it was the wrong category to look at. Because looking at culpability, what was said was that this was an instance of a breach where it'd been the defendant's partner who had been shouting and screaming outside of the property, rather than the defendant herself. Secondly, it was in terms of harm. It had quite a limited effect on others. Of course, it would have been distressing for the neighbours who witnessed it, and it did cause some harm, but it wasn't so serious to warrant that categorisation. So the Court of Appeal considered it should have been in a lower category on the basis of culpability and harm. The second issue related to adjournment, and in this specific case, the judge adjourned for a period of 6 months to consider sentencing. Miss Hopkins was warned that if there wasn't any improvement in her behaviour, the likely sentence would be a 12-week suspended sentence, suspended for 12 months. But what happened at the adjourned hearing was, unfortunately, it was 9 months rather than 6 months later. It's unclear from the judgment whether that was any fault of the County Court or not, but it's certainly lamented because it did cause further issues. But in essence, what the judge considered was the fact that the defendant wasn't able to prove that there hadn't been any further breaches and that she had complied. And the Court of Appeal considered that the burden of proof was not on the defendant, but on the claimant or the applicant to prove that there'd been non-compliance. And so there should have been a lesser sentence given than the original sentence that she was warned of. and the appeal was upheld, and Ms Hopkins was given no order. The second case in the appeal, which I want to look at, there were 3 specific points of appeal, which are all very interesting, but they weren't, or findings weren't made, they weren't upheld. So the first was a procedural requirement to provide a transcript and to upload onto the judicial website contained within CPR 81.88. And it was considered that although this was a serious procedural irregularity, particularly the failings of access to justice enabled the defendant to consider the sentence that was given, it wasn't so serious as to amount to the sentence being overturned in and of itself. The second ground of the appeal was that possession should have been considered as an alternative to the custodial sentence. And again, the Court of Appeal did not agree with that line of argument, noting that you would have needed to make an application for possession under the normal rules under CPR 55, and that wasn't necessarily an option open to them without that application, and it shouldn't be considered necessarily, or didn't have to be considered on the alternative. There was another ground of appeal relating to legal aid, which again isn't that relevant for our purposes. But what it did consider was that the appeal was, that the sentence given was too high, that it was 12 weeks suspended for 12 months. And that was based on the criminal behaviour order sentencing guidelines from 2018, which the judge had looked at and hadn't taken into consideration the fact that that bracket was up to 5 years rather than 2 years. And what was considered by the Court of Appeal is that there should be a 4-week suspended sentence, suspended for 12 months. Finally, I will leave you with paragraph 56 of the judgment, which again is very helpful guidance for practitioners considering sentencing and for the court and the judiciary when looking at sentencing. It cannot be overemphasised that the task of sentencing a defendant for breach of orders in contempt of court is a multifactorial exercise of judgment based on the particular facts and circumstances of the case before the judge. Any sentence must be just and proportionate. So again, that's really emphasising the need for careful consideration of all the facts. And although there's been some very helpful guidance and the CJC's framework that's been offered, it will be a fact-specific exercise. Thank you very much, everyone, for joining us, hopefully this afternoon or when you watch this recording. Hopefully you've enjoyed it, and please do contact our clerks at 42 Bedford Row if you have any questions.
Thank you. Goodbye.